Welcome to the Pretty Good Policy for Crypto podcast, where we have in-depth discussions on cryptocurrency policy and regulation. My name is Paul Brigner, and I'm head of U.S. policy and strategic advocacy for the Electric Coin Company. Through these thought-provoking and at times challenging conversations, we aim to deepen our understanding of complex policy and regulatory issues and work towards the development of pretty good policy for the cryptocurrency world. This podcast is for educational purposes only and is not legal or financial advice. My remarks and those of our guests may not reflect the views of our organizations. We hope you enjoy the podcast. Thanks for tuning in. It is my pleasure to welcome Marissa Koppel, Senior Counsel for the Blockchain Association, to the PGP for Crypto podcast. Marissa, I've been really looking forward to having you on this podcast. You bring some great experience, and you are filling a very important need here at the Blockchain Association. I have firsthand witnessed all of the added value that you've brought, and I think it's been over a year now, a little over a year that you've been at BA. Just being able to cover everything that's happening on the litigation front, which has probably been a lot more than you expected, I'm guessing. It has been a lot more than I expected.
Definitely.
Everyone in the industry over the past week has been focused on this Ripple ruling. It is a very important, I think maybe even a landmark ruling. At least it's been a while since we've had such a ruling. We've been waiting for this Ripple decision for 3 years now. So it was very exciting to see it come through. As you're reading through it, I was reading through it, and at first it seems to look not so good for Ripple, because I think it takes about 20 pages before it turns a little bit and you see some glimmers of hope. But in those first 20 pages, it's like, this is not going great. So it certainly wasn't all in favor of Ripple, but there was some major pronouncements, I think, for the crypto industry at large with regard to what is a security and what's not. And I know you've got all the legal details of this mastered. I want to hear those, but I want everyone to know before we step into any of this that you are not giving legal advice to anyone. I am not giving legal advice. We are not here to provide legal advice. We're here just to inform people about what we're doing and what our personal opinions are. And we're not giving financial advice either. So people should just enjoy this for casual content and not go out investing after they hear any of this content, for sure.
Yeah, thanks for giving the disclaimer, Paul. I am a lawyer, but I'm not anyone who is listening lawyer. So thanks for the disclaimer.
Great. So let's talk about it. I think we're going to talk about Howey, right? You can't touch on this topic without starting out with the Howey test, and I know that the court walked through that. So do you want to give your overview of how the court analyzed the situation?
For sure. So you're right that I think it was the first 20 pages, you're sort of like, this doesn't look too different from what we've seen in prior cases like Telegram or Kik. And what I think, just like at a very high level, the court broke down the sales into 3 buckets, which to me is a win, because in past cases, the court has really not differentiated between different types of sales of the tokens. So the 3 buckets were institutional sales, which was XRP sold to like institutional investors. And then the second bucket was called, the court called them programmatic sales. They sort of look like secondary sales, but it's really buyers who are buying XRP on the secondary market where there's a blind bid ask in like how the tokens were sold. But they're purchased on the secondary market, not directly from Ripple, or at least the buyers didn't know that they were purchasing them directly from Ripple. And then the third bucket, I think the judge calls them other distributions, and that's really XRP given out as grants or, like payment to employees or other people doing some sort of projects for Ripple Labs. So she broke them out into these 3 buckets, and in the first bucket, which was the first portion of the opinion, was regarding institutional sales. And those she found were part of a securities offering. And the reasoning looked similar to what we've seen before. So I don't know if you're reading it, you think it's like, okay, this isn't that different, not great for crypto. But there are a couple lines toward the beginning. I can't remember exactly what page they're on, but one key line she she distinguishes between XRP, the token, and an offering or a transaction that uses XRP. And she makes it very clear that XRP, the token itself, is not a security. It can be part of a securities transaction, but which is the investment contract analysis through Howey. But that transaction has to be analyzed, taking into account all of the facts and circumstances, and it's analyzed as a transaction, not necessarily like as the asset itself. So that line, I think, perhaps is like the most important line in the opinion, and quite frankly, a win in my mind for the industry, because Chair Gensler has really gone on a spree of making a statement that all tokens except for Bitcoin are securities. So Gensler conflates the token itself with the security, and it's really, is the token a part of a securities transaction? So I think that line was like very, very important, and hopefully that sets the stage for why so many people in this industry are viewing it as a win. And then there were a couple other helpful lines regarding the programmatic sales that really address whether a token is part of a securities offering when it's sold on the secondary market. Now, the court did include a footnote that seemed to suggest the court wasn't ruling on whether a secondary market transaction is part of a securities offering, but sort of reading between the lines of the opinion, it kind of seems like she's saying, like, it would be very hard for her to find a transaction on the secondary market as part of a securities transaction. So that was another win. And then thirdly, on the other distributions category of token distributions, she basically found that it didn't meet the investment of money prong of Howey. So because the recipient of XRP didn't actually invest cash or, some other monetary asset, then it didn't meet that prong of Howey, which when you read the Howey test, it says investment of money. So that's, pretty, it is what it says it is, right? So there's a history of courts outside of the crypto context, and actually, frankly, outside of the Howey context, expanding what money means to include some other form of consideration, but the court didn't do that here. So that could be important for something like an airdrop, whether it's just, either randomly distributed to someone's wallet or, given as part of a grant, which sort of would mirror the facts in this case.
Yeah, so that while there's a lot to discuss there, we talk a lot about decentralization and these factors that are being discussed currently in legislation and other things to determine what's a commodity and what's a security. Was that a factor? It sounds like maybe that wasn't even considered that much.
Yeah, it was sort of interesting because the Hinman speech and the documents surrounding those drafts were such a huge part of this case, just in the discovery process and wanting the drafts to be disclosed. And the judge didn't really use them in the opinion. So decentralization plays a factor in the efforts of others prong of Howey, just like naturally it does. And that mirrors what Director Hinman said in his speech in 2018. But in this opinion, it wasn't like a central component of the opinion. The biggest win of this opinion is that the judge very clearly states XRP itself, the token, is not a security, but it can be part of a securities transaction or a securities offering. So it's possible that XRP sold on the secondary market could be part of a securities transaction or a securities offering, but the token itself is not a security. So, it is hard to think about facts in which it's sold on the secondary market would be part of a securities transaction or a securities offering, but that's not to say that it isn't. It's impossible. In the same way that, the SEC itself has recognized that Bitcoin itself is not a security, it's a commodity, but Bitcoin could be part of a securities transaction or a securities offering. but that doesn't necessarily mean that Bitcoin itself, the asset, is the security.
Maybe you could give us some insight into the procedural stance of this case. Even though we're 3 years in, this was a motion for summary judgment. So that's one of the first things that happens after you do some of the discovery and other things, right? So you want to give us an idea of where we stand in the overall Ripple litigation?
Yeah, so it took 3 years. Most of that is because discovery takes forever, especially when both parties are, really litigating all of the issues and there's a lot of fights over documents. It can just extend the discovery process out for years. So that's what we saw happen in this case. And a motion for summary judgment is basically one or both parties, in this case, both parties, asked the court to rule on the case. Sometimes it's only on certain issues of the case before trial based on the evidence that is in the record at that time. So the court ruled on some of the claims on summary judgment, which means that those claims will not be tried. But there are claims, the aiding and abetting claim, that will be going to trial.
So that means, of course, we have these rulings. Is there any, aside from what we've already discussed, there were rulings that did not go in Ripple's favor? What were the implications of those?
So the rulings that I guess didn't go in their favor, they either went in the SEC's favor, like the institutional sales ruling, or the judge declined to rule on them, entirely because there was some sort of dispute of fact, which a jury or a judge during a bench trial would have to decide. So the judge on summary judgment will only issue a ruling if there's no dispute of material fact. That's the standard. But if there are disputes of fact, and the fact has to be material, so it's one that matters in terms of proving the elements required for the claim. So if there's no dispute of fact, then the judge can rule on summary judgment. But if there is dispute of fact, a trier of fact, which in many instances is a jury, sometimes it can be a judge, will rule on it or decide the fact at trial. So in this case, the case is going to trial unless the parties settle before it goes to trial. I don't think they will settle, but who knows? So now the next stage is prepping for trial and getting pretrial motions in and, evidentiary motions, and then the court has the trial.
One of the rulings was that the sales to institutional buyers were actually securities transactions, right?
Mm-hmm.
So that will not be litigated further, correct?
The only aspect of that will be litigated is the question of damages. So if the parties don't settle and decide on an amount that Ripple Labs would have to pay the SEC because they're being held liable for violating, that law, the jury then decides, or a judge in a bench trial will decide damages. So the amount that they would have to pay, the penalty, will be litigated during trial.
Do you have any expectation for how that will be handled going forward? It seems like these things often get settled.
They do often get settled. I know that, Ripple's been very aggressive in fighting this case. So I wouldn't be totally surprised if they take it all the way to trial. But oftentimes the damages question does get settled. It also depends on how incentivized the SEC is to settle.
In light of this decision, we've had in the markets, we've seen a lot of altcoins, as they are described, they've really taken a run lately. So that's been interesting to see. Do you think that this has broader implications for just altcoins in general? Is that something that someone would look at this case and walk away with?
To an extent, yes, but also no, because it is a district court opinion, which means that it's not precedent for any other court. So any other court in the country doesn't have to follow this opinion, and it's possible that it will get appealed. And if it gets appealed to the circuit court, then the circuit court is precedent for other courts in that circuit. but another circuit court can decide the opposite way. So if it goes all the way up to the Supreme Court, then it's the law of the land, and all courts in the United States have to follow whatever the Supreme Court says. But just because one district court issues an opinion doesn't necessarily mean that other courts have to follow that opinion. So it's possible that, for instance, in the Binance case, it's in front of a different judge in a different district. It's possible that the case will be decided differently.
Yeah, you mentioned appeal. So we haven't discussed that path yet. So what are your expectations for appeal here? It seems like I'm guessing that would happen in this case, right?
Yeah, so they either have to wait until trial is over, or they can seek something that's called an interlocutory appeal, which they have to get permission from both Judge Torres and the circuit court judge. I'm not sure if it's decided like on a panel of circuit court judges, but anyway, there's a process, and that process is kind of a tough burden that they would have to overcome in order to actually go that route. And it's a little bit unclear whether they would try to do that at this point. I know that the commission has publicly been celebrating the opinion, so I'm not sure how they view it, internally, but it seems like from their public communications that they're viewing it as a win. So it would be kind of interesting if they decided to appeal it at this point, like through this interlocutory appeal process. But otherwise, if they don't do that, it would have to wait to be appealed until after the trial is finished. And then that process itself could take, another couple years.
The trial itself.
Well, the trial itself, I'm not sure when it's set to start. I don't think that it might get pushed. I don't know when it's set to start, probably some point this fall. I doubt that will be a couple years, like until it's tried. Mm-hmm. But the appeals process itself could take a long time.
Interesting. Okay. All right. So none of this happens too fast.
No.
But after 3 years of waiting, it's nice to see some progress.
Yeah, for sure.
We're all very happy about that.
Definitely.
Marissa, I'm curious about your big picture view of this case. And of course, and again, a reminder to everyone that we're not giving any financial advice here. But what is the big picture view of like what does this mean to the ecosystem? What does it mean to Web3 or DeFi and things that other things that people might be interested in?
Yeah, it's a really good question. And yes, nothing I'm saying on this podcast is legal advice. So definitely do not rely on anything I say, legal or definitely not financial advice, because I'm like in no way capable of giving financial advice. But anyway, so I guess one thing is just with regard to Ripple and how it relates to Ripple. I think the opinion that we saw last week really shows that judges look critically at these issues. So it's not like a sure thing that the SEC is going to win when they bring an enforcement action, especially if the subject of the enforcement action fights back. So that's just one thing to keep in mind, and I think is just very positive and a positive reminder that came to us last week with this opinion. But the recent enforcement action against Coinbase does implicate staking. So we'll see, how the judge rules on those issues. And their staking program is it's a staking as a service. So it's almost like a IT function. But the SEC is characterizing it as a securities offering. So I'm hopeful that the court will understand the distinction between the two. And really, Coinbase is just providing a service, like a technology service. So that could have an impact on other staking programs going forward. But again, it might be some time until we actually receive a substantive ruling in that case. And then with regard to DeFi, I think like the secondary markets issues that were in the Ripple opinion, just those have broad implications and might provide more clarity on how Howey might apply to a secondary markets transaction, which would, in theory, apply in the DeFi context.
Sounds good. Well, maybe that's a good time to segue away from the specific cases and then to this paper that you and Jake Chervinsky worked on, analyzing the role of the SEC Chairman Gary Gensler. You want to give us an overview of that, and we can just discuss that a little bit?
Yeah, for sure. So our paper, which we published a few weeks ago, it basically makes the legal argument for why Chair Gensler should recuse himself from, this is very specific, from the decisions involving the Wells process. So to step back, like, what is the Wells process? So before the SEC files an enforcement action, they go through this process that they call the Wells process. And they basically issue what they call a Wells notice to the subject or the target of the enforcement action that says, these are the laws we believe that you're violating, and what part of your business is violating these laws, and we are thinking about bringing an enforcement action. But please respond to us and tell us your thoughts on, how the facts shake out, and most likely why you think we shouldn't bring an enforcement action. So then the company will hire outside counsel usually, and they do a whole investigation, and then they write a fairly long response, which they then present to the commission enforcement staff and try to convince them to not recommend to the commissioners to file an enforcement action. So once the staff reviews the submission, they then decide whether they want to recommend to the commissioners themselves that the commission should file an enforcement action or not file an enforcement action. And then the 5 commissioners will then vote on whether or not to file an enforcement action. So the commissioner a commissioner in analyzing whether or not to vote on whether to file an enforcement action is sort of acting like a neutral arbiter or a judge, where they're taking in the facts of both sides. They go into the situation with like an unbiased perspective, and then they decide whether they want to initiate an enforcement action based on the facts presented to them. And so what we've seen with Chair Gensler, where he's been making these public statements that all tokens, excluding Bitcoin, are securities, we think he is going into these decisions with a biased perspective. Like, he has already decided that the token that is being presented to him through this Wells process is already a security. So there's some bias there. And because he's acting, he has his neutral arbiter hat on rather than his prosecutor hat on, he has to go into this with an unbiased perspective. And the law, which we outline in our paper, requires him to recuse himself. A party can, if he doesn't recuse himself, a party can file a motion with the commission or file a motion in court once an enforcement action was actually brought, and ask for a ruling that Chair Gensler recuse himself or that the case be dismissed.
That was very helpful to go through the Wells process. I hear that a lot, but I don't hear a very good explanation like you just provided that gives all that detail. So that was fantastic. Where does this go? You've got this paper out there, I think is very convincing and compelling, a good argument. What can we do with that? How can we move that forward?
Yeah, so the paper itself is not legal advice. So we do not want anyone to rely on the paper as legal advice, but parties can use it in their discussions with their own counsel and ask, what their counsel thinks of these arguments, and perhaps, use that as inspiration for their strategy within their own cases.
I think this has been an inspiration for maybe some congressmen too, right? Didn't we see some activity on the Hill? Was your paper directly related to any of that or used by any of those congressmen in making suggestions about potentially removing Chair Gensler?
Yeah, I think our paper got a really good amount of attention. And I think I'm hopeful that Chair Gensler read it himself. He seems to be, couching some of his statements now with saying that he's not biased and that he's thinking through issues. I know that he gave an interview a couple of days ago that kind of used that disclaimer, but it definitely, I think, was celebrated by several different people and members of Congress, just as a very positive legal argument to have out there.
That's great. Well, thanks for that contribution. We appreciate you pointing that out and being a leader in the industry and giving some good legal analysis around this issue, because I think a lot of people have expressed frustration about the approach the SEC has taken, Chair Gensler in particular, but you actually put some analysis around it, which is great.
Yeah, I mean,
Very
it was great to work on with Jake. Yeah, it was an awesome thing to write together.
Does this relate in some way to the Wells process I'm referring to? Does it relate to what happened with Coinbase recently? Because wasn't there a lot of frustration there that they had started this process and had responded, put tons of effort into it, and then it was just hanging out there, right?
Yeah, so they actually made their Wells response public, which not all companies do, but they did put a ton of effort into the response and hired excellent counsel to draft their response. And I believe they were engaging with the commission. There was like some back and forth, but ultimately there's no like set timeline by which the commission has to, decide whether or not to file an enforcement action, and they can just file it, without like further notice to the subject of the enforcement action.
That seems to be a very one-sided process that can be highly abused. You could have companies doing tons of analysis and spending a lot of money on attorneys and defending what they're doing, and then nothing happens.
Yeah, I mean, in some senses, yes, that definitely is the case, that the whole process uses like a ton of resources, but the process is meant to afford targets of enforcement actions due process protections. And like not all agencies have that process. In theory, like the SEC doesn't need to have the Wells process and could just file an enforcement action against someone with just by surprise. So I think the Wells process does afford, some procedural protections, and sometimes the commission decides not to file an enforcement action. So it is like worth it for the company to go through that process and do their own investigation and draft, a really substantive response, which then in theory they could use during the enforcement action because it kind of lays out, so at least some aspects of what their defense would be.
Cool. So you're covering all of this litigation. That's a lot. I mean, it's been, I think, like the year of litigation. If I were at class, how many cases do you think you're tracking right now, roughly?
Oh man, I mean, I have a tracker, so.
Yeah, with like a multiple
like
pages
Excel spreadsheet tracker. I think like actively, I'm like thinking about how many rows there are on this thing. I don't know, like at least 20.
Wow.
But, it's continuously being added to.
Is there anything you're looking at like for near-term impact? I mean, is there something that you're thinking could drop any day that our listeners should be on the lookout for?
I think the thing that comes to mind most is the Grayscale opinion. And that's not a Howey case, but I think that will be the next big opinion that we see, and that's a circuit court opinion. So it'll be very interesting to see how the circuit court characterizes the SEC's choice to deny Grayscale the Bitcoin ETF.
That's going to be interesting in that we have these other ETF applications that have just come through recently. People are very excited.
I think they're anticipating that this decision's going to come out soon. So once it does, if it goes in Grayscale's favor, then I think they're thinking that their applications would be approved, like following the court decision.
Interesting. So do you think that the SEC is probably just sitting on those for the time being? Until
my guess would be. And they take forever anyway to get those things through. So, I mean, unless the commission has some
time limit,
I don't know what it is.
Yeah.
There might be. I'm just not sure there probably is, but I would imagine they could probably push it back for some reason too and like delay it.
For many cases, people just withdraw them if they don't want to.
Right, exactly. Yeah, so I don't know like what the commission's strategy with approving or not approving or sitting on them is, but I just imagine the timing of the applications being filed like seems to correlate with like an anticipated decision in Grayscale.
Okay, we'll be on the lookout for that. Let's talk about your role here at the Blockchain Association. Again, you've been here over a year now, and I think you, in the process, have moved. You've personally relocated. But even before we go into that, maybe we should start with how you even got interested in this space and what is your crypto story. You've had quite a bit of legal experience. You've worked for a district court, I believe, you have clerked, and done a couple of different things that are really very interesting. So how did that lead you to this place?
Yeah, so I've always been interested in technology. I think that's sort of, even before crypto came to be, I was always very interested in tech. My background is regulatory enforcement, defense work, and litigation. So I've started my career at O'Melveny, and then I clerked in the district court in LA. And then I went to Covington after my clerkship. And at Covington, I did mostly like white collar regulatory enforcement, defense work, and investigations with some litigation, definitely a lot of like pro bono impact litigation. And then at O'Melveny, I did truly like half investigations and litigation. And it was there during my first year when I worked on an SEC enforcement action of a crypto company. So that is really how I got started in the industry. And I just thought it was fascinating from a legal perspective because there was no precedent. And we were like trying to understand how the securities laws apply to this new technology. This was during like the ICO craze. So it was an ICO case. But I just thought it was very interesting, like intellectually very interesting. So since then, I continued to do my investigations and litigation work. I didn't do a ton of other crypto work. I think the firms that I was at, they didn't have like a ton of that work, although it was starting to get more and more. But I just continued to follow it from a personal perspective. And then when I was at Covington, I knew I didn't want to become a partner at a big law firm, and I was trying to figure out what I wanted to do next. I thought it would be very interesting to get in the tech sector and specifically crypto, just because of how like intellectually interesting to me it was. I also believe in the technology from a, creating more financial equity. There's transparency and also privacy, which is like weird that there's both, but there is. And it's like a very welcoming and open community. And I've always been sort of just like not the normal lawyer, you could say. Like I am very creative and spiritual, and I felt that this industry in particular like welcomed sort of like odd personalities like mine. So that was sort of, I decided, it would be really cool to go into crypto full time. And then I saw the position at the Blockchain Association open up. I studied public policy in college. And when I was deciding whether to go to law school, I was deciding between a JD and a master's in public policy. Ultimately chose the JD, but that public policy background and interest was still there. So I thought that the policy counsel role really like married the two of those, and it certainly has. And then in my role now, I'm senior counsel, and I do a combo of law and policy. Mostly I do a lot of like litigation related things, but then also writing comment letters and understanding draft legislation, FOIA requests, amicus briefs. So, and then, constantly like thinking about litigation issues, because that's sort of my bread and butter. But that's like how I came into the industry. And so I am like fairly new to it, like to doing it full time. And it's been like 2022 was just a crazy year. And I feel like I've been in it for longer than just a year or a little over a year. But it's been an amazing learning experience, and I've gotten such awesome opportunities, and like truly the industry is so welcoming, and like people are very, very open to answering questions. So it's been awesome so far.
You're a very committed and passionate person, and enlightened is the way I would say it. I think that's the way I see many people in crypto, is that they see a future that could be,
For sure.
and are open to that. So being open-minded, but also passionate.
And also like not being afraid to be sort of like on the fringe of society a little bit.
Yeah. Well, pushing the boundaries.
Yes, exactly.
That's right. But for the good of society.
For sure.
You just recently moved to the DC area
I
too.
did.
So a lot of personal change, and then other things in your personal life. So it's been like, what a year, right?
Yeah,
That's been pretty
seriously.
crazy. How's DC for you?
It's been great. Yeah, my husband and I were living in LA where both of us grew up. So I had been living there since I graduated from college. I went to college back east in Boston and then came back to LA after and worked and went to law school there and then kept working. So I had been living there for, I don't know, 15 years, I guess.
So Hollywood didn't grab you. You
No,
decided
I've
to
always
pick
had
up.
mixed feelings about LA. It's a beautiful, like the landscape is beautiful with the mountains and the ocean. But, you know, it has sort of, there's a scene that I'm not totally a fan of. Although if I have a lot of very close friends, my family is still there. But I think the move was a welcome change. And it's been really great to just be like close to the people that I work with and like really just like fully diving into the work. I think from LA, it was a challenge with the time difference. And then also it's just far. So I would travel here a lot, like once a month or so.
Yeah.
And it's a
a long
5-hour
trip.
flight. And then, yeah, I'd be gone for a whole week. So it was definitely a lot, like all the travel. And I struggle with FOMO constantly. So now I get to like mitigate my FOMO to some extent.
Yeah, you're here now.
Yes.
So you're really plugged in.
Definitely.
Are there any other activities, just either other blockchain association activities or other things you're looking forward to in the next few months or weeks? What's on your agenda that we should all be aware of?
Yeah.
If there's anything.
I'm excited for the Policy Summit, which is sort of a conference that's available to our members at the end of November. So that should be really awesome. It was amazing last year. So I'm really looking forward to that. And then in terms of conferences, I think I'll be at MainNet in September. And I'm actually very excited for fall in DC. So like
Yeah,
every day I
good,
think about
good.
it.
Marissa, it has been such a pleasure to have you on. Thank you for sharing all of your insights and knowledge on the Ripple case and other things that you've talked about today. Again, thanks for all of your hard work and dedication. And if there's something that comes out soon, we'll have you back.
Yeah, for sure. Thanks so much for having me on, Paul.